Welcome to the second part of Rule of Law. We were seeing Bachan Singh's case. In the facts, a few days prior to the occurrence in the midnight, Vidya Bai was awakened by the alarm and saw the appellant inflicting axe blow on her sister Biran Bai. On the attempt to stop the appellant, Vidya Bai got blown on her face and the ear with the axe, leading injuries on her face and ear, and which made her unconscious. Divan Singh, who was sleeping at the distance, woke up and shook and raised an alarm and waked Gulam Singh, sleeping at a distance from there. On seeing the appellant with the axe on Desai Bai's face, they both hurried to stop him. Noticing them moving towards him, the appellant left the axe and ran away. Divan Singh and Gulab Singh gave a chase to him but could not apprehend him. Later, Bachan Singh was tried and convicted and sentenced to death under Section 302 of the Indian Penal Code for murder of Desai Singh, Durga Bai and Viran Bai by the Sessions Judge. The High Court confirmed the death sentence given by the Sessions Judge and dismissed his appeal. Bachan Singh then appealed to the Supreme Court by special leave question raised in the appeal was whether the facts of his case was special reason for awarding him death sentence as required in Section 354, subsection 3 of CRPC 1973. The issues raised in this case was whether death penalty provided for the offence of murder in Section 302 Indian Penal Code given in 1860 is unconstitutional. Second, whether the fact found by the lower court would be considered special reason for awarding the death penalty as it required under Section 354(3) of CRPC. Now we will see the judgment. The Supreme Court dismissed the challenges pertaining to constitutionality of Section 302 of IPC and 354 subsection 3 of CRPC. The court further said that the six fundamental rights guaranteed under Article 19(1) are not absolute right. These rights are subjected to inherent restraint stemming from the reciprocal obligation of one member of a civil society to so use his rights as not to infringe or injure similar right of another. Also, it was made very clear by the court that Article 19, Clause 2 to 6 has expressly made subject to the power of the state to impose reasonable restriction on exercise of rights of citizen. There are several other indications also in the Constitution which show that Constitution may fully take cognizance of the existence of death penalty for murder and certain other offences under IPC, which was given in 1860. The expression special reason in Section 354(3) of CRPC means exceptional reason founded in exceptionally grave circumstances, the death penalty or an alternative imprisonment for life sentence that was awarded. The Apex Court laid down the principle of rarest of the rare cases in awarding death penalty. Those convicted of murder, life imprisonment is the rule and death sentence is an exception. It was held that the Supreme Court by a majority of 4:1 reaffirmed its earlier decisions and held that the provisions of death penalty as an alternative punishment for murder under Section 302 insofar it is neither unreasonable nor it is against the public interest. It violates neither the letter nor the ethos of Article 19 of the Indian Constitution. It is constitutionally valid and it exercises the discretion under Section 354 subsection 3 of CRPC 1973, which should be exceptional and grave circumstances, and imposition of death sentence should only be in the rarest of the rare cases. National discussion about death penalty has resurfaced from time to time. The Supreme Court addressed the question of constitutionality of death penalty for the first in Jagmohan Singh vs. State of Uttar Pradesh. The death sentence does not extinguish all the freedom guaranteed under Article 19(1), and it was also held that it was not violative of Article 14 of the Constitution on the ground that it is unguarded and uncontrolled discretion given to the judges to impose either capital punishment or imprisonment of life. Thus, the death penalty became the exceptional rather than a rule. However, Bachchan Singh's case decision did not elaborate the criteria for identifying the rarest of the rare cases. Bachchan Singh case also does not explain as to what falls under the purview of rarest of rare cases. Thank you.